Afternoon, everybody, and welcome to the webinar put on by SELECT and the Building Safety Group regarding the roles and responsibilities of company directors with regards to health and safety and the associated regulations and legislation that comes with that. So just to make you aware that this is being recorded and it will be available to watch back on YouTube at some point. So you can feel free to watch it again if need be. I'm just introduced to you. I'm Robert McGugan. I'm a technical advisor for SELECT and I'm going to be hosting this today. But most of today's webinar is going to be delivered by Andy Harper from the Building Safety Group today regarding the roles and responsibilities of the directors. If you have any questions, feel free to post them on the question and answers box that's available on your toolbar. So just click on that and feel free to ask any questions and we'll go through them at the end once Andy's finished his presentation. So moving on, like I've said, this is brought by SELECT and the Building Safety Group. As a lot of you might be aware, SELECT and the Building Safety Group joined forces in 2018, and SELECT members can use the Building Safety Group's technical expertise for health and safety advice and risks assessments as well. Some of you will be well aware that you've got free access to the risk assessment software available online. Like I've said, it's myself and Andy Harper that are presenting this to you. So I'm just giving you a presentation of it, and Andy Harper will be delivering the key aspects of the presentation. That's myself there on the screen. So just a wee bit about the Building Safety Group. They are the UK's largest not-for-profit construction safety group. Okay, so they're the UK's largest not-for-profit construction safety group. Their focus is entirely on the quality to ensure that they deliver the highest standards in health and safety advice and guidance. Okay, very much what SELECT do regarding electrical guidance. Building Safety Group are owned by the members, run by their members as well. Okay, so very much the way SELECT processes as well. It's a member organisation. Okay. Like I said earlier on, we've been in partnership with the Building Safety Group since 2018, and Building Safety Group gives SELECT members unlimited access to online health and safety information, and like I said earlier, including the risk assessment management software and health and safety advice. And like I mentioned earlier, just to reiterate, it is delivered free as part of SELECT membership. And Building Safety Group's mission is to support their members in driving continuous improvement in health, safety, and environmental performance by providing a consistent, high-quality professional service to ensure the well-being of all. Very good. About BSG, they have over 50 years of experience providing specialist consultancy services to their members. They conduct over 15,000 site inspections per year to over 800 members. So that's a lot of inspections they carry out throughout Great Britain. Like I've said before, they're experts in construction, health, safety and environmental welfare and have a unique insight into the construction sector. There's the 4 regional teams there. So you've got Scotland in the north, where the Building Safety Group cover, London in central, Bristol in southwest and southwest. And they've got technical inspectors, health and safety advisors in each of those areas. So I'm going to hand you over now to Andy Harper, who will deliver the presentations on the director's responsibilities with regards to health and safety. Over to you, Andy.
Thank you, Robert. Good afternoon, everybody. Today's webinar will be on director's responsibility. We'll cover various areas of this, including the Health and Safety Work Act and various other regulations, but also what the HSE demand of us as directors. First slide, Robert. So the Health and Safety Work Act. Obviously, from the slide you can see, it is dated 1974, so it's been around for 50 years. It's a very much an embedded act within UK law. And the Health and Safety Work Act is an enabling act, so that it covers various different regulations and enables various different structures, including the legal representation of the HSE. Next slide, please. So the Health and Safety Work Act itself sets out what employees and employers must do, and it describes something called by act or omission. So act or omission means what you do or you don't do. And in particular, for directors are concerned, it refers to sections 2 or 3. Section 2 of the Health and Safety at Work Act covers everybody who works for us, and section 3 covers everybody else. Next slide, please. So everybody whilst at work has a legal responsibility for health and safety, their own health and safety, and anyone else in the workplace. One of the things we'll touch on later on is to cover what our employees must do, but everybody whilst at work has a legal responsibility. Next slide, please. All the regulations we use in construction health and safety are stem from the Health and Safety at Work Act. They are statutory instruments of that act. So they all stem from there. Next slide, please. Covering each regulation should be an approved code of practice or a legal guidance document. Very useful. A lot of money is spent by the HSE in putting these together for us to use, but they are a two-edged sword. So it tells us how to meet the requirements of each regulation, but they can be used in prosecutions should we not choose to do so. Next slide, please. So employers' legal duties. It encourages us to look after our own people, to make sure we do what is required of us, but also to engage with our stakeholders. Right? The term used is successful health and safety management. Okay. Next slide, please. In health and safety, we talk about reasonably practicable. So everything we do must be reasonably practicable under the Health and Safety at Work Act, Section 40. And what that means in proper terms is the cost of this against the risk. Anything which is high risk, cost cannot be considered. You know, we can't say it was too expensive to do something if it's a high risk. And the reverse onus of proof is on us. So we must make sure we do what is appropriate. Next slide, please. So employees' legal duties. What that means is that although we are directors and we're required to monitor and maintain whatever we do, our employees have a legal duty as well. The key part in successful health and safety management is making sure our employees buy into this and are engaged, and their duties are understood and managed to a degree as far as we can. Next slide, please. The Health and Safety Executive. The Health and Safety Executive have opinions about what directors should do, and it's well documented about what they broadcast as far as the directors of companies they deal with. Next slide. The Health and Safety Executive, they actually state that directors should at least annually review systems of control that are key to the fulfillment of the company's business objectives. Risk management, financial, operational, and compliance. What that means is, in real terms, is that they believe that any company, the health and safety requirements are a key pillar of that business. So they would expect us to take the same focus on health and safety as we do as financial and legal compliance with tax, etc., etc. Next slide, please. They use enforcement. So inspectors can visit premises and places for two basic purposes: proactive, so planned preventative inspections, and reactive, investigations in response to RIDDOR reports or complaints. Planned preventative inspections are part and parcel of what the HSE do. They visit premises and make sure that what they see is up to speed, but they can actually turn up at a premises or place of work following a RIDDOR report or a complaint by somebody to their reporting structure. They use various different mechanisms. One of them is an improvement notice. So that requires action to be taken to remedy a breach of statutory legal duty with a specified time period. At least 21 days must be given, which an appeal in an industrial tribunal can be made. They can extend these term of notices. They can make making an appeal suspends the notice until the terms are confirmed or amended by the tribunal. But these notices, including the prohibition notices, last for 5 years on our record. So anybody could look our company details up on the agency websites and look up what's happened to us and actually specifically what we've got wrong. Next slide, please. Prohibition notice can be issued where an inspector's opinion is that the work activity presents a risk of serious personal injury. It requires a specific activity to cease. But what it doesn't do is close the site, but it stops the work which they believe. They'll specify that in their prohibition notice to us. We can appeal again, same process and procedure, and the hearing, the appeal hearing will then determine whether the terms of the notice are upheld or should be amended. Next slide, please. The next weapon in the armory of the regulator is fee for intervention. So they can turn up at our place of work and they can decide that they issue a notice of contravention, that there's a material breach. That triggers a intervention where they can charge us for their time. At this present time, they can charge us £174 per hour. The average fee for intervention, latest averages for fee for intervention, are around per notice of contravention of around £1,500. Next slide, please. So the law. Next slide. The HSE prosecute under criminal law. So it's all a criminal. There's no civil matters as far as this is concerned. It's a criminal law, under all criminal law. Next slide. Section 33 of the Health and Safety at Work Act describes what the offences are. So it's an offence to fail to discharge a duty imposed by sections 2 to 7. And as I said earlier, section 2 is anybody who works for us. Section 3 is anybody else. And that covers the majority of scenarios. It also says to contravene sections 8 or 9 of the Health and Safety at Work Act, section 33. Normally in construction, that is covered by CDM. They don't normally enforce that at levels with us in construction. Or C, to contravene any health and safety regulation, to intentionally obstruct an inspector in the execution of their duties. Bearing in mind the HSE carry a warrant card, the same as the police, and they have powers of intervention and powers of entry onto our sites or places of work. Obstructing them is obstructing, same would be as obstructing a police officer. Also an offence to make a false statement to the inspector, to make a false entry in any register or book kept under any regulation, or fail to comply with the requirements of an improvement or prohibition notices we just covered. Next slide, please. Section 37 of the Health and Safety at Work Act provides that where an offence is shown to have been committed with the consent, connivance or neglect of a director, manager or secretary, both the corporate body and the individual may be prosecuted and punished accordingly. We'll cover some of the prosecutions a little bit later. Next slide. What's negligence? Negligence stems from a tort law, an old-fashioned tort law, that remedies to individuals harmed by the unreasonable actions of others. And negligence is described as a breach of a legal duty to take care that results in undesired damage by the defendant to the claimant. In our health and safety world, it's 3 essential elements of proof provided by the claimant, an existence of that duty. So that existence is clear because as employers and as directors of a business, we have a duty to look after our employees. A breach of that duty and the damage or injury. Once you have those 3 elements of proof, then that would be described as negligence. Next slide, please. Case law. Personal liability. Case law confirms a director cannot avoid a charge of neglect under Section 37 by arranging their organisation's business such that they are ignorant of circumstances which would trigger their obligation to address health and safety breaches. So therefore, when somebody says you were negligent, there's no way we can organise ourselves to say we didn't know anything about it. And the burden of proof, again, remains with us. Those found guilty are liable to fines and in some cases imprisonment. Next slide, please. If we get to court involving health and safety prosecutions, the court can curtail our ability to be a director with the Company Directors Disqualification Act. It empowers the court to disqualify an individual convicted of an offence in connection with the management of a company in the same way as all the other requirements. But this includes health and safety offences and is exercised at the discretion of the court, and it requires no further investigation or evidence. They can make a decision there and then. Next slide, please. Individual directors are also potentially liable to other related offences, such as the common law offence of gross negligence manslaughter. Under common law, this offence is proved when individual officers of a company cause a death by their grossly negligent behaviour. This is punishable by life imprisonment. The Corporate Manslaughter and Corporate Homicide Act 2007 came into force in 2008, and it covers the company, but a gross negligence manslaughter will still continue to apply to individual directors. Next slide, please. So culpability, personal prosecutions, culpability levels, very high. Offender intentionally breached or flagrantly disregarded the law. High, actual foresight of or willful blindness to risk of offending, but the risk nevertheless taken. And even medium culpability, offence committed through act or omission which a person exercising reasonable care would not commit. These are all how they're described in the culpability within the law and the sentencing guidelines. Next slide, please. The lowest one is low offence, committed with little fault, for example. Significant efforts were made to address the risk, though they were inadequate on this occasion. There were no warning circumstances indicating a risk to health and safety, and failings were minor and occurred as an isolated incident. Should this be described as the culpability level, you're not going to be in court. They don't normally prosecute anybody with the lowest level of culpability such as this. Next slide, please. Health and safety policy. Health and safety policy describes your health and safety ambitions, right, to everyone concerned, your employees, and anyone else affected by our business, including our customers. All right. I would advise everybody to, if they have a health and safety policy, to make sure they read it and understand it, including what they would expect of their own employees. Next slide. Where an employer has five or more employees, we must prepare a written safety policy and bring it to the notice of all employees. The policy should set out the organisation and arrangements for enforcing the policy, and the policy should be revised as and when required. All SELECT members will have access to our library of documentation, including a very robust health and safety policy template. It is geared up for a slightly bigger company, but reducing it down is no big problem, and you can take it and tailor it to suit your own needs. Next slide, please. This slide comes from a health and safety senior principal inspector in construction, and he describes this as the problems the HSE find. So planning, managing, and or monitoring, checking, auditing, inspecting, looking, asking. Almost all construction incidents and concerns the HSE investigates involve a lack of or deficiency in one or more of these elements. What he truly describing is the fact that we cannot hope for the best. We cannot be ignorant of what goes on with our employees and what our company is up to, if you like. All right. Next slide, please. So, directors, how do we communicate this to our employees? We need to communicate and consult with our employees and ask for their and seek their cooperation. And we do this via our health and safety policy, our inductions, site safety briefings, and toolbox talks. Next slide, please. The HSE believe that many company directors do not pay sufficient attention to the impact of boardroom decisions on the allocation of health and safety resources at operational level. So the HSE, by this statement, may be giving us, as the regulator of our industry, a sign that they don't actually believe an awful lot of directors do enough. Next slide, please. So what you must do for your company, the company needs to accept formally and publicly its collective role, whatever size you are, in providing health and safety leadership in its organization. Each member of the company needs to accept their individual role in providing health and safety leadership for their organization. So remember what the employees' duties and responsibilities are as well. Next slide, please. The board of directors, if that's applicable, needs to ensure that all board decisions reflect its health and safety intentions, as articulated in the health and safety policy statement. And the board needs to recognise its role and engage with the active participation of workers in improving health and safety. Next slide, please. Directors should ensure that when decisions are made, the health and safety implications are fully considered. They should ensure that the company health and safety performance is reviewed at least twice a year at board meetings. I would say more than that. They should ensure that adequate resources are available to allow staff to carry out their duties in a safe and efficient manner, allowing for continuous personal development. That can mean training. The board should set a good personal example when engaging on company business by demonstrating absolute commitment to health and safety at all times. Next slide, please. Directors, they should ensure all staff, particularly those engaged in construction site activities, have been fully trained, and by a continuing process of training sessions and instruction, satisfy themselves that all employees remain competent in the discharge of their duties. What do we deem competency? Well, we use an acronym called SCATE. So S is for skills, K is for knowledge, A is for aptitude, and then the T is for training, right? And then the last one, E, is experience. So it's not just about training. Anybody who works for us and is out there today, working out in the field or out in our business, we've deemed them competent already. We must be able to prove it. We should ensure work equipment used by the company employees is suitable for the purpose and maintained in a safe condition. Next slide, please. So this slide comes from a barrister who regularly defends directors who are in breach of health and safety law and are before the courts, and avoiding prosecution, fines, and custody. So be positive. We're positive about our business. We're positive about how we've organised ourselves. Don't have an accident, which is an easy one. Have a good system. So our health and safety management system, in whatever form, needs to be robust. Know your duties. I would include knowing your duties as in knowing the duties of your employees as well. And fulfill your duties and make sure everybody knows it, both before and after the accident. It's called defending early. Defend early, before the accident, prevent the accident. So by having a good system, we've prevented accidents, but if we have an accident, we know it was a low culpability level, as I described earlier on. Any questions, anyone?
Thanks very much for that, Andy. And I'm just a wee look here just to see if there is any questions. Just a wee second here. There's a couple here, Andy, if you don't mind. First of all, it says, if I sign the health and safety policy, am I the only director responsible? So if this is obviously meaning if there's more directors,
yeah. No, all directors are responsible.
right.
The senior director who signs the health and safety policy normally is the person who's asked any questions by the regulator or anyone outside the business. But all directors are responsible. Just because one's signed the policy doesn't mean that they are any more responsible than any of the others.
Okay. And then should the health and safety policy list all the directors?
You can in some policies have a family tree, if you like, and an organizational chart, but you don't have to list them by name. It's not a legal requirement, but somebody senior at board level or director level will need to sign the health and safety policy.
Okay. I think that's all we've got. I'll just double check. I don't see anything else in the Q&A there. I'll just have a wee look in the chat box there. That seems to be it.
Okay. I am going to, as I said earlier, I'm going to forward a document, very useful document called INDG 417 from the HSE and the Institute of Directors to Select for you to download and use. It's a workbook, very useful for developing anything you feel you need to do as a company director. It explains things very, very openly, and it deals with a format which we champion, which is called Plan, Do, Check, Act. And with that, it helps directors prove what they're doing.
Okay. Well, thanks very much for that very useful presentation, Mandy. And I hope our members take a lot away from it regarding directors' roles and responsibilities. And say thanks very much again.
Okay.
Thanks for that, Andy. Now, like I said to everybody involved participating, this is available to watch back later on. So if you need to pass it about your company, if your company's not had a chance to see it, and let everybody kind of watch it for CPD, etc. Okay. Thank you.
Thank you.
Cheers.